Court of Appeal for Abuja on Thursday discharged Nnamdi Kanu, the leader of the indigenous people of Biafra, IPOB, of the charges where federal government summer for him head. Justice Joma Hanetu will lead the three-man panel talk say Kanu no get case to answer as the Federal High Court no get jurisdiction to try him in the first place. Court rule say as them drag Kanu come Nigeria by force they illegal because them no follow extradition process. Court also talk say to detain or try Nnamdi Kanu they prohibited by law. It all these things with the appeal court for Abuja talk, people they ask question whether Nnamdi Kanu don't they free to go house. Wetin the ruling mean? Abuja-based human rights lawyer Samuel Ahensikian tried to break down the ruling for contrary people to understand. Barrister Samuel tell BBC Pidgin say him they salute the courage where the appeal court get to give this judgment, and with wetin the appeal court talk, Nnamdi Kanu they free to go him house. He explains say one person or people no take due process to follow law or comply with the existing law the consequence be say he go render the whole proceedings illegal. The capture of Nnamdi Kanu back to Nigeria dey against the Nigeria Extradition Act, he dey against the African Charter of People and Human Rights, he also dey against every law wey dey govern international law. Before you extradite anybody or a citizen from any African country you must first follow the extradition laws of the country and follow the due process of the court. Not until the court give you permission you fit return the person to face any trial for him country. But for this case, we just hear say Nnamdi Kanu surprisingly appear for Nigeria like angel, no procedure, no documentation, no official record. He add say wetin court do be say, them uphold the extraordinary rendition, where them they arrest citizen from one country, carry them go another country without due process. OGA Samuel talk say Nigeria government no get any choice now other than to let Nnamdi Kanu go. As he be so, Nnamdi Kanu no freeman, court don't pronounce free, so him dey free, federal government no get any choice other than to comply with the Court of Appeal ruling, he talk. Wetin fit happen next? Barrister Samuel Ahensikian tell BBC Pidgin say the only option for federal government now not to carry the matter go Supreme Court, but even if federal government go carry the matter go Supreme Court, them go first obey the judgment of the appeal court. This no case we border on the liberty of a citizen, them need to comply first with this judgment before them take any other step, because it go dey wrong to still detain and one court done discharge him of all the charges, he talk. Meanwhile, member of Nnamdi Kanu legal team, Alo Ejimeka tell BBC Pidgin immediately after the ruling say, one we call it the judgment paper tomorrow, Thursday, we go serve Department of State Security, DSS, so that them go release am sharp, as he be so, Nnamdi Kanu no free man, Aloy talk. Wetin government talk? Federal government lawyer David Kosuwe no talk to Torai people after the judgment. But one statement from the Office of the Attorney General of the Federation said them they studied the judgment to determine their next line of action. Them also clear the public say for the avoidance of doubt and by the verdict of the court, Kanu only they discharged and not acquitted. The statement talk. Consequently, the appropriate legal options before the authorities go they exploited and communicated accordingly to the public. The decision way they handed down by the Court of Appeal now on a single issue way border on rendition. Make it they made clear to the general public say other issues before the rendition on the basis of which Kanu jump bear remain valid issues for judicial determination. The statement add. Them say the federal government go consider all available options open on the judgment on rendition while them pursue determination of the pre-rendition issues. The 7-count charges where Nnamdi Kanu been they appeal. Nigeria government been summarily proscribed IPOB leader 15-count charge we border on terrorism, treason, secession and that him be member of IPOB group we government done outlaw. But for May 2022, Justice Binta Nyoko of the Federal High Court removed some of the charges from 15 to 7. Not the remaining charges below the appeal court through on Thursday. Count 1. Say Nnamdi Kanu as member and leader of IPOB commit act of terrorism against the Federal Republic of Nigeria by making broadcasts with intention to intimidate the population. Count 2. say Nnamdi Kanu as member and leader of IPOB commit act of terrorism against the Federal Republic of Nigeria by making broadcast with intention to threaten members of the public with sit-at-home order. Count 3, say Nnamdi Kanu make broadcast where he declare himself as member and leader of IPOB, group where Nigeria government don ban. Count 4, say Nnamdi Kanu make broadcast where he encourage members of the public to kill Nigeria security officers. Count 5, say Nnamdi Kanu make broadcast where he encourage the public to attack officers of the Nigeria police force. Count 13, say Nnamdi Kanu make broadcast where he encourage members of the public to burn down every federal government facility for Lagos will lead to major economic loss to federal government. Count 15, say Nnamdi Kanu import radio transmitter known as Tram 50L and hide a inside container for Jubilation for Ihiola local government area of Anambra. Nnamdi Kanu case so far. Timeline of Nnamdi Kanu and the indigenous people of Biafra movement. Nnamdi Kanu, non-Nigerian separatist leader and founder of the indigenous people of Biafra, IPOB, one group wey want a breakaway state for southeast Nigeria. He found IPOB for 2014. Kanu grew up for southeast and attended the University of Nsukka. He moved to the UK before graduating. Soon after he set up IPOB, he spoke to gatherings of the large Igbo diaspora, calling for Biafran independence. For some of him comments, he asked Biafrans to take up arms against the Nigerian state. We need guns and we need bullets, he been talk for one of such address. And that no wetin bring am to the attention of Nigeria security services. Kanu dey seen by many as a dangerous propagandist, but he dey also considered as a lightning rod for the way many Igbos still feel unhappy about Nigeria, years after a 3-year civil war between 1967 and 1970. Authorities arrest Nnamdi Kanu for 2015 when he returned to Nigeria, but this only boost in profile. The man wey many Nigerians been dismissed as troublemaker, even within an ethnic group, become the most talked about Igbo person. Kanu formed the Biafran Security Services, BSS, one mock militia wey dey dress in black and do parades for the eastern city of Abia, im home state. As the Nigeria government see say group dey overdo too much, court come declare IPOB as terrorist group and ban their activities. For September 2017, the Nigerian army carry out one raid for Kanu house, but he escaped. Many been think say that not the end, but Kanu reappear for Europe for 2018 and continued the radio broadcast way he been done they do before. For late 2020, he resurrect the BSS and rechristen the Eastern Security Network, ESN.
Nigerian court drops charges against separatist IPOB leader. Nigeria's appeal court has dropped all charges against separatist leader Nnamdi Kanu after ruling that he had been illegally arrested abroad. The court also ruled that his extradition had been illegal. The ruling by a panel of 3 judges is seen as a major blow to the government, which had detained Mr. Kanu on various treason and terrorism-related charges. He leads the banned Indigenous People of Biafra, IPOB, group. IPOB is campaigning for the creation of an independent state in southeastern Nigeria. Mr. Kanu, who holds a UK passport, fled Nigeria in 2017 before he was seized and brought back in 2021. His 2021 arrest abroad was illegal because extradition protocol was not followed, the court said. Kenya has not commented on whether it played a role in Mr. Kanu's deportation to Nigeria. The appeal court also ruled the Federal High Court did not have the jurisdiction to try Mr. Kanu. He initially faced 15 charges, but 8 had previously been dropped. He was originally arrested in 2015, but he fled Nigeria in 2017 while out on bail. He had previously denied any wrongdoing. IPOB wants a group of states in the southeast of the country, largely inhabited by members of the Igbo ethnic group, to break away from Nigeria and form an independent nation called Biafra. In 1967, Igbo leaders declared independence for the state of Biafra, but after a civil war, which led to the deaths of up to 1 million people, the secessionist rebellion was defeated. But the idea of Biafra has never gone away, and despite the arrest of his members, Mr. Kanu's movement has seen a recent swell in its numbers. The Court of Appeal in Abuja, on Thursday, quashed the terrorism charge the federal government preferred against the detained leader of the indigenous people of Biafra, IPOB, Nnamdi Kanu. It discharged and acquitted him of the 7-count charge pending against him before the Federal High Court in Abuja. The appellate court, in a decision by a 3-man panel led by Justice Jomai, said it was satisfied that FG flagrantly violated the law when it forcefully rendered Kanu from Kenya to the country for the continuation of his trial. It held that such extraordinary rendition, without adherence to due process of the law, was a gross violation of all international conventions, protocols, and guidelines that Nigeria is signatory to, as well as a breach of the appellant's fundamental human rights. The appellate court noted that FG failed to refute the allegation that the IPOB leader was in Kenya and that he was abducted and brought back to the country without any extradition proceeding. It held that FG was ominously silent on the issue, which it described as very pivotal in determining whether the trial court would still have the jurisdiction to continue with the criminal proceeding before it. In law, that is a costly failure, and such failure is an admittance by the respondent. Where a party fails to controvert a deposition by an opponent, the issue not contested is deemed conceded, the court held, adding that the onus was on FG to prove the legality of the appellant's arrest and return from Kenya. More so, the court noted that Nigeria is a signatory to OAU Convention, which it ratified on April 28, 2022, as well as the Charter of Human and People's Rights, which it said prescribed how a wanted person could be transferred from one country to the other. It held that any extradition request must be in writing, with a statement indicating offenses for which a person is wanted. The appellate court held that FG's action tainted the entire proceeding it initiated against Kanu and amounted to an abuse of criminal prosecution in general. The court will never shy away from calling the executive to order when it tilts towards executive recklessness, the appellate court held, even as it accused FG of engaging in serious abuse of power. Nevertheless, the appellate court said it would be prejudicial for it to make an order on the proscription of IPOB since the issue is still on appeal. It held that the proscription order by the lower court would subsist until it is set aside.
Owerri erupts in joy as court frees Kanu. There was jubilation in Owerri, the Imo State capital, on Thursday evening. Immediately news filtered in that an appeal court in Abuja had discharged and acquitted the detained leader of the indigenous people of Biafra, Nnamdi Kanu. Across parts of Owerri, such as Imo State University Junction area, Ikonegbu, Amakovia, Oji, Okigwe Road and Flyover Junction, people were celebrating and ordering for drinks following the development. At Flyover Junction, a commercial driver was seen shouting and honking that Nnamdi Kanu had been freed at last. He said, "Victory at last. Motsi Nnamdi Kanu has been freed. It is victory for Biafra." At IMSU Junction, groups of youths were seen at different quarters shouting and singing following the development. One of them was heard saying, "Victory has come to Ola Igbo at last. Motsi Nnamdi Kanu is a free man. There won't be sit at home again. Glory be to God." Breaking news. Court of Appeal acquits, discharges IPOB leader, Nnamdi Kanu, says rendition from Kenya illegal. The court was ruling in the appeal filed by Kanu, challenging the criminal charges against him. The Court of Appeal in Abuja has ruled that the rendition of the detained leader of the indigenous people of Biafra, IPOB, Nnamdi Kanu, from Kenya was illegal and therefore he should be discharged and acquitted. The court was ruling in the appeal filed by Kanu, challenging the criminal charges against him. In the update on the court ruling provided by Kanu's lawyer, Ifeanyi Ejiofor, he said, "Update on Motsi Nnamdi Kanu's abduction and extraordinary rendition from Kenya is declared illegal and consequently constitutes a bar to further proceedings/trial. Court held that it was done in clear and egregious violation of extant international laws. There is no justification whatsoever. Even the warrant of arrest issued in Nigeria cannot justify the illegality in the abduction and extraordinary rendition of Nnamdi Kanu. Appeal allowed, Nnamdi Kanu, discharged and acquitted. We have won. Victory, 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 victory. Kanu had been rearraigned before a federal high court on amended 15 counts bordering on treasonable felony preferred against him by the Nigerian government. However, on April 8, Justice Binta Nyoko struck out 8 of the 15 counts. While ruling on the preliminary objection seeking to quash the charges, the judge said counts 6, 7, 8, 9, 10, 11, 12, and 14 had not disclosed any offense against the defendant, Kanu. The charges that were struck out below are as follows. Count 6, made broadcast to attack officers of the Nigeria Police Force. Count 7, made broadcast in which he incited members of the public to hunt and attack officers of the Nigerian Police Force. Count 8, made broadcast in which he directed members of the IPOB to manufacture bombs. Count 9, made broadcast on diverse dates in furtherance of terrorism against the Nigeria state and with intent to destabilize the fundamental political and economic structures of Nigeria, incited members of the public to stop the Anambra governorship election. Count 10, incited members of the public to destroy public facilities. Count 11, threatened members of the public not to come out on May 31, 2021. Count 12, made broadcast with the intention to incite members of the public to stage a violent revolution in furtherance of acts of terrorism. Count 14, directed members of the public to destroy the public transport system in Lagos, resulting in major economic loss to the governor. Nyoko had said that counts 1, 2, 3, 4, 5, 8, and 15 showed some allegations, which the defendant had to answer. However, Kanu, through his team of lawyers led by Mike Oscombe, SAN, filed an appeal marked C8/ABJ/CR/625/2022, praying the court to quash the remaining 7 counts for being devoid of merit. The appeal is equally praying the court to order his release on bail, pending the determination of his appeal. Ifeanyi Ejio for ESQ, IPOB's lead counsel, in a statement sent to ONIF TV, said judgment would be delivered on Kanu's appeal on October 13, 2022 at 2 p.m.
Appeal Court discharges Nnamdi Kanu, challenges High Court's jurisdiction. The Appeal Court sitting in Abuja has discharged the embattled leader of the proscribed indigenous people of Biafra, Nnamdi Kanu. Kanu is being prosecuted by the federal government at the Federal High Court in Abuja for 15-count charges bordering on treasonable felony, terrorism, and offenses he allegedly committed in the course of his separatist campaigns. A 3-man panel of the Court of Appeal, however, said the Federal High Court lacks the jurisdiction to try him in view of his abduction and extraordinary rendition to Nigeria in flagrant violation of the OAU Convention and Protocol on Extradition. The court held that the 15-count charge preferred against Kanu did not disclose the place, date, time, and nature of the alleged offenses before being unlawfully extradited to Nigeria in clear violation of international treaties. The court further held that the federal government failed to disclose where Nnamdi Kanu was arrested despite the grave allegations against him. The court noted that the act of abduction and extraordinary rendition of Kanu from Kenya without due process is a violation of his right. It added that the manner in which Nnamdi Kanu was procured and brought before the court was not evaluated by the lower court before assuming jurisdiction to try him. The lower court, having failed to address the preliminary objection challenging its jurisdiction, particularly the issue of abduction and extraordinary rendition from Kenya to Nigeria, the lower court failed to take cognizance of the fact that a warrant of arrest can only be executed anywhere within Nigeria, the appeal court judgment said. The court further held that the trial judge was in grave error to have breached the right to fair hearing of Nnamdi Kanu. The African Charter on Human and People's Rights are part of the laws of Nigeria, and courts must abide by the laws without pandering to the aim of the executive, the appeal court said. Treason charges. Mr. Kanu has repeatedly called for the breakaway of a significant chunk of southern Nigeria to form the Republic of Biafra. On October 2015, he was arrested by Nigerian authorities on an 11-count charge bordering on terrorism, treasonable felony, managing an unlawful society, publication of defamatory matter, illegal possession of firearms, and improper importation of goods, among others. He was granted bail on April 2017 for medical reasons. However, Mr. Kanu fled the country in September 2017 after an invasion of his home by the military in Afraku, near Umuahia, Abia State. He was then cited in Israel and later continued to rally his supporters in Nigeria to employ violence in achieving secession. He has, upon jumping bail, been accused of engaging in subversive activities that include inciting violence through television, radio, and online broadcast against Nigeria and Nigerian state and institutions, Minister of Justice Abubakar Malami said after Kanu was rearrested and brought back to Nigeria in June 2021. Kanu was also accused of instigating violence, especially in the southeastern Nigeria, that resulted in the loss of lives and property of civilians, military, paramilitary, police forces, and destruction of civil institutions and symbols of authorities. Mr. Kanu has denied any wrongdoing.